We will call our first case, which will be People versus Randolph.
May it please the Court, Eve Primus on behalf of Mr. Randolph. Michael Middlestad is with me at counsel table. I'd like to reserve 2 minutes for rebuttal, and I know to keep my own time. I'm also happy to waive the free fire zone.
Thank you.
In this circumstantial murder case, the State relied on junk science, inadmissible hearsay, and illegally seized evidence to convict Mr. Randolph. The Court of Appeals properly found multiple evidentiary errors and deficient performance by trial counsel, but it distorted the Strickland prejudice requirement in 3 ways to avoid reversal. First, it relied on a fictional account of evidence that the State never presented to downplay the prejudice. Second, it impermissibly heightened the Strickland standard. And third, it failed to consider the cumulative effect of defense counsel's many errors in this case. I will address each one in turn. As this Court knows, one of the State's key pieces of evidence against Mr. Randolph was the result of a preliminary gunshot residue test that was performed on his hands on the night of the murder. 2 different police officers were called by the State to testify that this test showed that Mr. Randolph had gunpowder on his hands. But this test is scientifically unable to reach that conclusion. After hearing from a defense expert at the Ginther hearing in this case, the trial judge deemed the test scientifically unreliable. Counsel at trial never objected to the admission of this test, and the Court of Appeals rightly deemed his performance deficient. Had the Court of Appeals conducted a proper Strickland prejudice inquiry, it would have found that the admission of this seemingly scientific evidence undermined confidence in the outcome of the trial. After all, it was a circumstantial murder case. There were no eyewitnesses. There were no confessions. And the prosecution had emphasized in its opening statement that this gunshot residue test was a key piece of evidence that would connect Mr. Randolph to the crime.
Ms. Primus, can I interrupt you?
Of course.
Why exactly is how the Court of Appeals, why isn't it just a little bit sloppy, the way the Court of Appeals addressed prejudice? I mean, why shouldn't we read the Court of Appeals analysis to be saying, because the defendant could not satisfy prong 3 of the plain error test, which is the place where we would look at, the equivalence between the Strickland prejudice and the plain error prejudice. If the defendant couldn't satisfy that under our plain error test, then certainly he couldn't satisfy the prejudice requirement under Strickland. Well, because it could have been said more clearly, but why shouldn't we read it to have said that?
Because what the Court also said, Justice McCormick, was the evidence that it was relying on when addressing the prejudice requirement with respect to the gunshot residue test. And what that Court said was that if the defendant had objected to the admission of the gunshot residue test, that then the State would have called an expert to testify, and then the defense would have called an expert to testify, and then the evidence that would have been presented to the jury would have been suggestive that Mr. Randolph had gunpowder on his hands rather than conclusive. In effect, the Court of Appeals made up a record. There was no expert presented by the State. There was no suggestion in this case that this was only suggestive for gunpowder residue. And the Supreme Court of the United States has said in both Strickland and in Wiggins v. Smith that that's not how you do a prejudice inquiry, that you look at the record in front of you when you're analyzing whether there was prejudice in a given case. The Court of Appeals didn't look at the record. It went beyond it. On this record, the evidence that was presented at trial was that Mr. Randolph had gunpowder on his hands. It wasn't suggestive, and defense counsel did nothing to undermine that conclusion. That was incredibly prejudicial in this circumstantial case, and part of what made it so prejudicial is because it was seemingly scientific evidence. In Daubert, the United States Supreme Court explained the dangers of junk science, that courts, often jurors in particular, associate scientific evidence with this mystic infallibility. The trial judge in this very case explained what the prejudice would be during the Ginther hearing. He said on the record, all those TV talk shows, all those crime shows talk about gunpowder residue. And he explained how jurors in his courtroom routinely during trials ask, did the police perform a gunshot residue test? They ask that question because they think it's reliable, because they think it's important. Having been erroneously told that Mr. Randolph had gunpowder on his hands, they believed that he had fired a gun. It didn't matter to them how much the prosecutor emphasized it. It didn't matter to them, right, that there was no other evidence that specifically indicated that Mr. Randolph was the perpetrator on that night in question. What mattered to them was that there was a seemingly scientific test that suggested he was guilty. And I'm reminded of something the United States Supreme Court said recently in a different context in the case of Buck versus Davis. The United States Supreme Court explained in Buck versus Davis that some toxins can be deadly in small doses, that sometimes a piece of evidence and the impact that it can have on a jury can't be tied to the amount of argument time in closing that is spent devoted to that piece of evidence. And seemingly scientific evidence that is junk science that tells a jury in a circumstantial murder case that the defendant fired a gun on the night of the offense is deadly toxin in any dose in this case. But that wasn't the court's only error.
No, I was going to say, well, but putting it aside, so assume that we agree with you that that in fact the Court of Appeals discussion about how it might have gone down if there was an objection was not appropriate given the record. But assume it was the testimony wasn't admitted at all. Could the Court of Appeals have said there was still enough other evidence that the defendant loses in terms of the prejudice analysis? No,
because that was one of the key pieces of evidence that actually connected Mr. Randolph to this offense. And that wasn't the only error. If that was the only error that the court had made, that would have been one thing. We still think there's enough here to suggest that that had a reasonable probability on the outcome in this case, given the scientific nature of the evidence and the circumstantial nature of the case. And I would also point out, like, that evidence came in through the testimony of 2 police officers, which, as this court recognized in People versus Bynum, there's more of a likelihood for jurors to show deference to police officers because their testimony comes with this aura of credibility and trustworthiness. I'll also point out the prosecution, in its roadmap to the jury, emphasized that this was a key piece of evidence. So in light of all of that, it had a very prejudicial effect on the outcome in this case.
Well,
but that wasn't...
How yes. prejudicial could it have been, given that the prosecutor conceded that these results were not something to give a whole lot of weight to? I mean, what would that communicate coming from even the prosecutor in this circumstance?
Well, in that very same sentence, Justice Markman, the prosecutor also said it was a factor that the jurors should consider, but that it wasn't necessarily something to give a whole lot of weight to. And what I would point this court to is what the Supreme Court said in Buck versus Davis, which is it isn't always about how much airtime a piece of evidence gets in the prosecutor's closing argument or how the prosecutor frames it, that there's some pieces of evidence that are just so powerful vis-a-vis a jury that it carries its own independent weight. When the trial judge in this case said that 5 times a year jurors will hand up questions asking for gunshot residue, that's independent of a prosecutor saying anything about it.
Wouldn't one think that the most powerful evidence, the most prejudicial evidence was not the residue evidence, but the fact that the murder weapon was found in his apartment?
Well, Your Honor, the murder weapon was found in the room of an apartment in which he shared with his brother and was in the room that was his brother's room. And the jury was told that his brother was on parole for a violent offense. So given those facts, it's also possible that the jury could have thought that his brother is the one who had committed this offense. We would also submit, right, that that piece of evidence should never have come in itself, was subject to suppression had defense counsel done a minimal amount of Fourth Amendment research to figure out that there are cases such as United States versus Waller and all of the other cases we cite in our brief in support of a motion to suppress.
But there again, there's no history of any particularly adverse relationship between the brother and the deceased, whereas there are threats within the previous several days that had directly been made, apparently, by the defendant.
And those threats were not admissible either, is one of the things that we are contending, which is another thing that was wrong with what the Court of Appeals did in this case, is that it failed to conduct a cumulative Strickland prejudice analysis. It went through each of the alleged errors that defense counsel made and then dismissed them without considering.
So we have somebody who committed the killing, but nonetheless you believe that there is evidence there that it was inappropriately admitted. Is that right?
No, Your Honor. I don't think there's enough evidence in this record to conclusively let the jury decide whether he committed the killing.
I'm saying evidence on the whole record, including those things that you believe should be suppressed.
Well, part of the reason, Your Honor, why I would say that hearsay should be suppressed is because
I'm not quarreling with your argument that if it should be suppressed, it should be suppressed and it shouldn't be considered, but nonetheless, that's pretty substantial evidence when it's added up that is pretty fairly suggestive, I think, that the defendant may have committed this murder.
Your Honor, I would say part of why we exclude hearsay evidence is because of its unreliability. So the threats that you are mentioning.
Was the murder weapon hearsay evidence?
No, but as I mentioned before, that's also something that was found right in a room that wasn't his room.
And certainly we'll consider whether or not we think that evidence was properly admitted, but my question was that if you add all that evidence together, it seems to be pretty suggestive that defendant was the likely perpetrator in this case.
And I would submit to the court that the jury.
We're not supposed to consider that, but I mean, nonetheless, it's not completely beyond the boundaries that a reasonable person might look to the totality of this evidence and try to assess who was responsible for the killing. Was it the brother or was it the defendant?
Yes, but respectfully, the standard is whether a reasonable probability of a different outcome was possible in this case, whether the errors that counsel committed undermined confidence in the outcome. And it's the jury's determination to make whether they believed that he was guilty beyond a reasonable doubt. Counsel's deficient performance in this case infringed on, the ability of a jury to make that based on admissible evidence.
I was just making the perfectly ordinary argument that the fact that he's, in my judgment, the evidence is pretty substantial that he committed the killing. We do have to take out those things that were improperly seized or that for some other reason may not be admissible. But that doesn't mean that we have to look in the face of this case and say that what is isn't.
Well, I would also say that part of what animates the Strickland standard is a consideration of whether someone had a fundamentally fair trial. As Strickland itself said, right, the ultimate touchstone here is a question of fundamental fairness. And in that, they said we should not mechanically apply the reasonable probability of a different outcome standard. If there is enough evidence in the record to suggest that a person did not have a fundamentally fair trial, that might be enough to demonstrate the need for reversal independent of whether there was an effect on the outcome in this case.
Why don't you make the argument that the evidence should not be considered? I mean, you're skipping over that right now, of course, and I'm not here to dictate the way that you argue the case, but why don't you focus on why this evidence that seems so compelling should not be part of the consideration of guilt or innocence in this case?
Well, I think I have argued that the gunshot residue test is based on junk science, that there's actually no way that it could demonstrate the presence of gunpowder on someone's hands. With respect to the alleged threats that my client made to Vina Fant, which she then relayed to Linda Wilkerson on the day of the shooting, that was impermissible hearsay that was clear on the face of the record. As this court said in People v. Gee, in order for there to be sufficient evidence to demonstrate the existence of an excited utterance, three conditions have to exist. It's got to be a startling occasion that's startling enough to render an utterance spontaneous and unreflecting, and it has to have been made before there was time to contrive or misrepresent. Here, the record demonstrates that there was sufficient time, significant time, for Vina Fant to contrive, think, and reflect on these statements. She specifically chose not to share them with her fiancé, with her grandson, with a family friend who was in the room at the time when Miss Linda Wilkerson came home. And Linda Wilkerson herself testified that she was waiting until all of those individuals left in order to share this information with Miss Wilkerson. That kind of figuring, that kind of waiting to figure out who you'd like to share information with and under what circumstances is precisely the amount of time for reflection that renders this not spontaneous and reliable. And I would submit with respect to the weapon that Your Honor made reference to, there's a long line of cases in this jurisdiction explaining that Mr. Randolph's father did not have actual or apparent authority to consent to the search of Mr. Randolph's belongings on the night in question, and that this gun was discovered as a direct result of the ammunition that was found during that search. Because the Court of Appeals failed to consider the cumulative effect of all of these errors, that in and of itself should be enough for reversal. In essence, Mr. Randolph was entitled to a fair trial. He was entitled to a lawyer who would provide competent representation. He had neither of those, and we're respectfully requesting that this Court reverse the Court of Appeals determination and remand this case so he can have the fair trial to which he's entitled.
Can I ask you about the attenuation argument, if you don't mind?
I'm sorry?
Can I ask you about the attenuation argument?
Sure.
It seems to me the factors here in support of the attenuation is that there was at least a 2-month gap between the illegal conduct and the acquisition of the murder weapon. ATF officers interviewed Kenesha and were informed that the defendant owns 3 firearms, including a 9mm during that interim period. And it seems to me that while the purpose of the police conduct was obviously to identify incriminating information, it wasn't of the kind of excessively flagrant character that seems to be one of the factors in traditional attenuation arguments. It's not wholly without understanding that the police officers, who are presumably not attorneys, would believe that the law allowed them to search defendant's belongings, which were in his father's home, with the father's consent. I agree that was probably an unconstitutional search, but nonetheless, was it the kind of unconstitutional search that was so flagrant and so excessive that it couldn't be fairly considered within the attenuation context?
I would submit yes, Your Honor, because there were 5 Sixth Circuit cases and 2 Supreme Court cases that explained that this was not a situation in which they had the authority to actually ask the father for permission to search Mr. Randolph's belongings. This was something that had been clear law since the 1970s in the case law.
And I'm not disputing that here. I'm asking whether it is appropriate to consider that in the attenuation context, not in the context of determining whether in the first instance it constituted a constitutional violation or not.
Yes, certainly. One of the most important factors in the attenuation analysis, as Your Honor points out, is the flagrancy of the misconduct. And the fact that there is long-standing precedent is one of the things that makes this conduct so flagrant. They had Mr. Randolph in their custody. If they wanted consent to search his belongings, they could have asked him for that consent. They also knew, because Mr. Randolph's father told them, that he didn't have authority, apparent or otherwise, over Mr. Randolph's belongings. The combination of those factors demonstrates that they knew and flagrantly disregarded that there was no actual or apparent authority to search those bags. Now, Your Honor also mentioned the passage of time, which is one of the factors. But I would point to the Sixth Circuit's decision in United States v. Gross and the Fourth Circuit's decision in United States v. Nagier as indicating that the passage of time is most often a relevant factor when you're dealing with the admissibility of confessions as fruits, because as time passes, the ability for an individual to assert free will and actually give a statement because he wants to is different. It is less important when what you're looking at is the suppression of physical evidence. The more key factors when you're looking at the suppression of physical evidence are the flagrancy of the misconduct and the presence of intervening factors. The reference that Your Honor made to the fact that they spoke to Kenesha Fant in the intervening time is not a part of the record. It is part of a pleading that the State offered. The State has the burden under Nix v. Williams of presenting evidence to the court to demonstrate that there was some independent source or way to inevitably discover this evidence. The State never presented anything in the way of evidence to support that there was an independent source or inevitable way that it would have found this gun.
So how was it they came to learn about these weapons?
They came to learn about these weapons because they illegally searched Mr. Randolph's belongings and found ammunition, which Agent Bernritter used to get a warrant to figure out that he was a felon in possession and therefore to get an arrest warrant for him. The police testified on the record that they spoke with Kenesha and learned that he was at his brother's house. That is the extent of what is in the record, that they learned he was at his brother's house. That's what led them to his brother's apartment, where they executed the warrant. And it was because they had that warrant and executed at the brother's house that they learned of the brother's parole condition and searched the house to find the gun.
So what has erroneously caused me to believe that they had an interview with Kenesha, who focused them on the murder, on the fact that defendant possessed a variety of firearms?
Because in the state's pleading, in response to our motion for a Ginther hearing, they indicated that and attached reports to suggest that they thought that that had occurred. But that was never presented at the trial, and it was never presented at the Ginther hearing. It is not evidence before any of the lower courts in this case. We have no idea what those agents would have testified to had they been called, but they were never called. And as the court said in Strickland and in Wiggins, the determination of ineffectiveness has to be made based on the record that was before the trial court. Thank you, Your Honor.
Thank you.
May it please the Court, Michael Tesner, Assistant Prosecuting Attorney for Genesee County, on behalf of the plaintiff, appellee. The people requested this Court deny the application for leave to appeal. We also request that you find that the Court of Appeals correctly applied the plain error review standards and the Strickland analysis. Also, the Court should clarify, for the sake of the jurisprudence, that a finding of no prejudice under the third prong of the plain error review precludes a finding of prejudice under Strickland when the allegations are premised on the same grounds, because those prejudice prongs are identical. The Court has requested that we answer two questions. The first, whether the defendant's failure to demonstrate plain error precludes a finding of ineffective assistance of counsel. And where the Court finds no prejudice under the third prong of plain error, then the defendant cannot prevail on an ineffective assistance of counsel claim that's premised on the same grounds. And that's because, in answer to number two, the prejudice standard under each of those two analyses are the same. The prejudice standard of the third prong of plain error review is, as is under ineffective assistance of counsel, whether there was a reasonable probability of a different outcome absent that alleged error. And this is so because the Supreme Court, and as was expressed in our brief, the U.S. Supreme Court has borrowed the standard from Strickland to impose it or to express it as the third prong of the plain error review, and that was in Dominguez-Benitez and also in United States v. Marcus in 2010. And in this court in 2015 in People v. Smith, although in a footnote, because it wasn't applicable to the case, outlined that or stated that an error in plain error review, when an error clearly occurred and the error clearly affected the substantial rights insofar as we find that it had a reasonable probability of affecting the jury's verdict. That's the third prong, as this Court has recognized, which reflects what the Supreme Court has said, the U.S. Supreme Court. So because this Court has adopted the federal plain error standard, as was recognized in People v. Kane in 2015 and in other cases, that is the standard. That's the expression by the U.S. Supreme Court. And so this Court should clarify that that is the standard in Michigan.
Counsel, assume that makes sense. You would have to agree with me that our case law has at least been sloppy on making that clear. And you might welcome some clarification, it sounds like, on that.
I agree. I think the case law has been less than definite on that, and that's why I'm asking that the Court clarify that. What's your view then on the way in which the Court of Appeals addressed the relationship between plain error and ineffective assistance of counsel? For example, with respect to the Fourth Amendment claim, the Court of Appeals said because the defendant didn't establish plain error, his ineffective assistance of counsel claim must also fail. It sounds to me like you would have, if you were able to write the opinion, you might have said because he couldn't establish prejudice under the third prong of our plain error test, he can't establish prejudice under Strickland, and you might have preferred
that the rulings say that. Is that fair? Is that a fair assumption?
That's exactly what I'm saying.
Yeah.
And I think that's what they were saying, because they did analyze.
Well, it's not what they did say, but you think it's what they meant?
That's not the, yes, that's why I think that's what they meant.
Is that good enough for us? Is it good enough that, I mean, if just because they could have done it correctly, if they didn't, should we
Well,
not
yes,
worry about it?
and I say that because they analyzed each of the errors, or the alleged errors, under the plain error standard.
Yeah.
And they determined either it wasn't plain error, well, actually, they determined some of that wasn't plain error, and a couple they said were error. But they said even assuming that there was error, there was no prejudice, because it didn't affect the outcome. And I think in making that finding, that precludes an ineffective assistance of counsel claim to succeed on the same basis for not objecting to whatever that evidence was, because they've already decided that it did not prejudice the case.
So what do you make of the cumulative error question in this particular case? I don't assume we agree with the Court of Appeals on the errors that the Court of Appeals found. And so if you analyze any one of them in isolation, you might have a strong argument that there's no prejudice given the other evidence. But if there was error with respect to the Fourth Amendment issues, and none of that evidence should have come in, and then assume there was also error, or there was, with respect to the gunpowder evidence, what do you make of the cumulative error analysis? What do we do with that?
Well, I think that I agree with Your Honor that the Court of Appeals should have addressed that more specifically. Mm-hmm. That because you can have, under ineffective assistance, you can have errors that cumulatively would cause prejudice to the outcome of the case. I mean, that's established in the case law. But in this case, I think the way that they reviewed the evidence and they determined that under clear error, each error in consideration of the entire case did not cause a different outcome. Did not cause outcome determinative prejudice. And so I
Do you think that's accurate, though? I mean, do you genuinely believe, if you look at the facts of this case, taking it cumulatively based on the evidentiary issues that were presented, that if you took it as a totality, that it really wouldn't have an effect on the jury's outcome?
I do, and let me explain why. Because the facts in this case, as Chief Justice Markman has pointed out, are compelling.
Aren't they compelling because doesn't that also ultimately become circular? They're compelling because, in effect, they become more compelling when you bring them all together. And if this evidence hadn't been introduced, doesn't that ultimately make it a little bit more intense in terms of kind of the way that this trial came out?
Well, it depends on what you consider to be error. But there was evidence from Kenesha that she had a fight with the defendant, that they had fought, that there was animosity, and in fact there was a knockdown, drag-out fight where she had a knife and he choked her out and took the knife and then left his belongings at her house. And then there was evidence that later that day, because this all happened within a day.
But go to the gun residue, though. I mean, ultimately the evidence was introduced, and when the prosecutor then says, hey, we're going to introduce this evidence about gun residue, but don't take it that seriously. It's not that important. I mean, in a way, like, don't you kind of consciously know, kind of going to Sister Counsel's point, don't you kind of know what the intention is of introducing that evidence? I mean, every layperson or anyone that hears Gunpowder Resident who's watched any of the, 50 cop shows that are on television every single night, especially CSI, is going to say, oh, gun residue, just like what Sister Counsel was saying. So don't you kind of think that when you bring that evidence in, you're doing it with that kind of deliberate intention of effect?
Well, I assumed from the opening statement that the prosecutor expected the evidence was going to come in, and in the way that it did come in was not the way that he had planned. And in his closing, he said that, don't give this too much weight. I don't think that evidence, in the face of the other evidence admitted at trial, caused prejudice to the outcome, because in addition to having a motive, the defendant made threats, some of which you may argue were inadmissible, but some of them they were admissible. There were threats made by the defendant who called the victim's boyfriend and made the threats and acknowledged what had happened that day, and I'm going to take care of it, or something to that effect. He explained at trial that the defendant's voice was angry, that he was upset, and he said he was going to do something about it. Even if that was the only threat that you think would be allowed, that's a threat from the defendant about what happened, and calling the victim's house, not the girlfriend's house, the victim's house, who he knows to be the girlfriend's mother, so Vina Fant. And then, based on the defendant's arrest and the search of the place he was living, they found the murder weapon. They found the gun that matched the bullets in the house, in the victim, and the casings that were found outside. So even without the gunshot residue, I think there was no one else that had a motive. So I think the gunshot residue did not cause prejudicial.
What about if you had what about if the Fourth Amendment issue, what about if the search and seizure issue had gone a different way in terms of the consent to the search? What if the gun had not been admissible? What do you think the impact of that would have been?
Well, I think without the gun, we probably wouldn't be here. I think there probably wouldn't have been a trial if they had not found a gun, because that's what tied the murder to the defendant. But I don't think that's dependent necessarily on the search.
So then you agree the Court of Appeals got the prejudice analysis wrong with respect to the Fourth Amendment question, I guess.
No, because the Court of Appeals determined that first, with regard to the ammunition, which is not what I'm talking about, but they said that the ammunition, the finding of the ammunition in the defendant's clothing and bags that the victim's daughter, Kenesha, had left at the defendant's father's house. They said that he had abandoned that at Kenesha's house, and that Kenesha had taken it over to the defendant. But the defendant didn't know it was there. He didn't even know it was there, and that he had abandoned it.
You're answering a different question than the one I asked.
Okay, I'm sorry.
It sounds to me like if you're incorrect about whether there was a Fourth Amendment, I understand you to be saying there was no Fourth Amendment violation. But if you're wrong about that, and therefore counsel should have litigated it, and the gun therefore would have been suppressed, your answer to Justice Bernstein reveals that you think that must have been that obviously was prejudicial if it was error. Unless you want to change, unless I misunderstood.
Well, I guess I'm not understanding. I think that the finding of the gun, as the conversation between the Chief Justice and my opponent, the finding of the gun was attenuated from the search of the ammunition. I don't think
that's a good argument for why there was no Fourth Amendment violation, but it sounds like your answer to Justice Bernstein is there was no Fourth Amendment violation, not that it wasn't prejudicial. You think obviously the gun. You said we wouldn't be here if there was no gun.
I think probably not.
Okay, I gotcha. Thank you.
But you were addressing Justice McCormick's question on cumulative error, and I don't think either. If you finished the answer, I missed it. So, if we agree with the Court of Appeals on its error, how do we deal with the cumulative error?
Well, I mean, given that the Court of Appeals found that there were no, I believe they found there were no plain errors, except for with regard to the ammunition, which they also said, despite the fact that they found error in the court's allowing, or I guess in the defendant's not objecting to finding the ammunition at the father's house. But they said, even if that were error, that it had been abandoned, and therefore I don't think they found any error that affected the outcome. And so when there is no error that affected the outcome, there's nothing to accumulate. And I think that's what happened in this case. But they didn't specifically address it, but they did say, examine every allegation of error and say there wasn't error, and assuming that there was, it wasn't outcome determinative, so it wasn't prejudicial.
Well, counsel, the finding of the gun was likely a fruit of the unconstitutional, if it was unconstitutional, the unconstitutional search of the ammunition, unless attenuated. To me, to the extent that there can be a reasonable finding of attenuation, it's almost certainly going to be based in significant part upon Tanisha's statement concerning the presence of guns in a certain location. Why is Ms. Primus wrong in suggesting that that itself is evidence that's outside the record?
Well, examining this under ineffective assistance of counsel, which is the way it was raised, it wasn't testified to at trial, although Agent Bernmitter did testify at trial that he had heard about the ammunition at the house, and then he talked to he talked to Kenesha, and based on that, he got an arrest warrant for the defendant. We know that there was a police report from the ATF that indicated he had spoke to Kenesha, and Kenesha told Agent Bernmitter that the defendant had possessed weapons, 3 guns, including a revolver, and had possessed ammunition. The defense attorney in the Ginther hearing acknowledged that he didn't oppose the evidence because he knew that it would have been fruitless, because the information came to the ATF separate from the search of the house. I mean, that was how it came to his attention, but he spoke to Kenesha and then got an arrest warrant. And the record could have been better at trial, but that is what he said in the record. He said he spoke to her, and based on that, he got an arrest warrant. And I know that there's a police report. Whether it was introduced as an exhibit at the Ginther hearing, I don't recall.
Isn't that a significant issue?
It is, Your Honor. I agree.
Isn't it really, if not dispositive, at least a very significant factor in the attenuation connection?
If the court is to find that there was a Fourth Amendment violation of the search of the belongings at the father's house, which we contend were abandoned, then I think it does have importance, because then we would have to show attenuation from that to the search.
How could they have been abandoned? He had left, a couple of days earlier? He hadn't indicated they were abandoned. You're basically presuming they were abandoned for reasons that are not entirely clear to me.
Well, it wasn't a couple of days. It was that day, and it was the day that he fought with Kenesha, and her son was calling the police, so he stormed out of the house and left his stuff at her place.
So that's the equivalent of abandonment, getting upset with somebody with whom you're living?
Uh-oh, I do that a lot.
Well, in this case, in the situation that we had, I think he did abandon his property at her house. He left it. He could have taken it with him, but he didn't.
I suppose he could have.
But he didn't. And he didn't ever go back to live there. He knew he wasn't welcome there. I don't know. I mean, to leave your stuff at a place where you're not going back, I think that's abandonment.
You do agree, though, that if the court does not agree with you that there was abandonment, and it doesn't agree with you that somehow the evidence set forth by Tanisha's statement is relevant or admissible evidence, that the gun, which you consider to be the sine qua non of your prosecution here, is kind of lost, isn't it?
Well, I don't think so, because there was another reason that was attenuated from the previous search, which was that the ATF found out that the defendant was they found out the defendant's brother was on parole, and that he was living at a location where they believed there were, well, actually, even without believing that there were guns or ammunition at that place, the parolee granted permission for a parole agent to search his house at any time. And that's in the record. And in addition to that, they went to search the house. Sergeant Bernritter testified that they contacted his parole agent and they searched the house it was a parole search. And the police are entitled to tag along on a parole search, and if there's evidence that's discovered, they can seize it. And that's what happened. So in addition to the fact that Sergeant Bernritter only obtained the arrest warrant after speaking to Kenesha, he also understood that the defendant's brother was on parole and that, in fact, it's probably a parole violation also to be living with a felon, which the defendant had a prior felony conviction. But at any rate, he testified because the brother had allowed or consented to a search by the parole agent of his house, that was a lawful search, and that's when they seized the gun.
What's striking to me that you didn't mention either of the two things that I actually mentioned when I was discussing this issue with Ms. Primus, the 2-month gap, and the fact that this was arguably not a particularly flagrant violation of the Constitution, both of which I thought have been viewed as relevant factors historically under the Supreme Court's 3-part attenuation test. What am I to make of your failure to invoke those issues?
Well, Your Honor, as you already had mentioned them, I guess I failed to repeat that, but I also, and I think they are important, and they do have an effect on attenuation, as Your Honor stated. Okay. But there were independent bases as well.
Okay, thank you very much, Mr. Tesner.
Thank you, Your Honor.
I think your time is up, but let's see if there's any further questions.
I'll have a question. I'm going to ask you kind of a general question, because I know you had asked before if you could have some time. How do you respond to the Fourth Amendment issue with the gun?
Thank you, Justice Bernstein. I would say counsel for the state has admitted that there wouldn't even be a prosecution here without that gun, that it was incredibly prejudicial if it was erroneously admitted. And I would point out to the court that when looking at the chain of events here, it is very clear that this gun was discovered as a result, based on this record, of the illegal search of Mr. Randolph's belongings on the night in question. The evidence in the record is that Agent Bernritter spoke to Sergeant Jones and the police department and learned about the ammunition that had been found from them. They were the police officers who performed the illegal search. He then spoke to Kenesha and found out where the defendant was and executed the warrant at the defendant's brother's home. It was only because he was at the home executing that warrant that he found out that the brother was on parole and therefore used that as a basis to conduct the search. The chain of events is never severed. There is no intervening circumstance, and there is nothing in the record that suggests that there was any independent source or inevitable way that they would have found that gun. So that chain of events is locked in the record as the only method that we have in this record for how they found that weapon. Now, there is a delay in time. That is true. But because this is a piece of physical evidence, that is a far less relevant consideration, according to the Sixth Circuit and the Fourth Circuit, in the attenuation analysis. And what matters to the courts most in the attenuation analysis is the flagrancy of the misconduct. And I would submit here that it was incredibly flagrant misconduct by the police officers in this case, because they were on notice factually that these belongings were Mr. Randolph's belongings. They were told that he had packed them up, that he had expressed, right, an intent to keep those items private. Mr. Randolph's father testified at the Ginther hearing that Mr. Randolph was particular about his things, that he had not touched those items, that he didn't feel like he could consent to a search of those items. And Sergeant Jones, who authorized this search, knew that Mr. Randolph was in custody. And there were 5 directly on-point cases dating back 30 years explaining that it completely undermines the Fourth Amendment if you can ignore obvious evidence that someone does not have apparent common authority and ask that person for consent to search. I would submit it was an incredibly flagrant violation and that there was nothing to break that chain of events such that this was evidence that should have been suppressed, and opposing counsel admits that that would be prejudicial. The final thing I would just point out about this with respect to the analysis of plain error and Strickland is what the Court of Appeals actually said about this evidence. They just assumed that there could not be an ineffective assistance of counsel claim predicated on a Fourth Amendment violation because they had not found plain error. That conflation of the plain error and Strickland prejudice analyses is problematic for multiple reasons, right? The first one is that they're based on different records, right? Even in Dominguez-Benitez, the Supreme Court of the United States said the Strickland record is larger than the plain error record. Plain error is connected to what was presented at trial, and the Strickland analysis includes what is developed at a Ginther hearing. And there was evidence relevant to the Fourth Amendment claim developed at the Ginther hearing.
Ms. Primus, what is your best argument to the suggestion that any reasonable investigation by law enforcement authorities here would have inevitably led to Tanisha, who is the girlfriend of the defendant?
My best response is Nix v. Williams, which says it is the state's burden to present actual evidence to suggest that something inevitably would have been discovered. It is not permissible for the court to engage on a speculative inquiry that suggests maybe, right, they would have found out something that would have led them there.
Doesn't it necessarily involve speculation? It's obviously a hypothetical development. It's not a certain development, and most it can be the result of a reasonable investigation. Wouldn't that have almost certainly, inevitably, to use the precise term, led to the girlfriend of the defendant?
The only thing that is permissibly speculative about the independent source and a hypothetical inevitable discovery, or hypothetical independent source or inevitable discovery doctrine, is the ability to figure out what the police would have done in light of the record evidence that is presented. There is nothing in this record that suggests the police were engaged in a course of conduct that would otherwise have led them to Mr. Randolph's brother's apartment to find that weapon when they did. There was nothing that anyone testified to at trial or during the Ginther hearing that suggested some other investigation was underway, that they'd asked Kenesha Fant anything about weapons, that they'd asked Kenesha Fant anything about where they might find those weapons. In Nix v. Williams...
There's apparently no need for that kind of evidence, given what the inclinations of the trial court were in this case, right?
Well, but at the Ginther hearing, the state knew we were alleging there was a Fourth Amendment violation, and they knew it was their burden to present, at least produce evidence to suggest if there was an independent source or some inevitable way to have discovered this, and they presented nothing. And so this court can only make the determinations based on the record that it has before it, and the record that it has before it is that the reason the police went to that apartment was because of information they found during a legal search of Mr. Randolph's belongings at his father's house.
Okay. Thank you, counsel.
Thank you very much.
The case will be submitted.